procedure meeting. First of all, can I just check, is everybody hearing me clearly? Raise your hand if you are. Give me a wave. Excellent, thank you. Now, I've issued an agenda for the meeting. Do you all have a copy?
Yeah.
Yes.
Yeah. Yes.
I hope we're not going to have too many freezing problems, but I was asking if you had copies of the agenda for today's pre-hearing meeting.
Yes, we do.
Has everybody got, Mrs. Gregory, have you got something?
Yes.
Very good. Okay, so having introduced myself, I'd like to move on to item 2 on my agenda, which is what we call the appearances, which is just to be sure who's participating in the meeting. So I'd like to start with the applicants. Who's leading the meeting for the applicants?
That will be me. Oh,
sorry.
Right.
Sorry. Oh, sorry. Yes, we're the applicants.
Yes, you're the applicant. So
Yes.
who's leading the meeting for the applicants?
That would be me. Andrew Ryan, partner, TLT Solicitors.
I had another freezing episode here.
Yes.
When I freeze, does anything happen with yourselves? Do you get kicked out of the meeting at all?
No, it seems to be okay. Certainly at my end.
Well, hopefully it'll settle down. What I was asking Mr. Ryan was, Ms. Dark, is she one of your client group? Ms. Dark.
Hi, yes, I'm Emma Dark, also from TLT Solicitors.
Oh, right. You're also, so your clients as such are not represented this morning?
Yes, Mr. Hugh Innes is attending.
Oh, Mr. Innes is, right.
Yes.
Mr. Innes is here, but he's not showing up on my screen, and his mic isn't on, so that's fine. Okay, having got you straight. Now, the objecting landowners, Mrs. Gregory, that's yourself.
Yes.
And you just clarified for me that your husband's not available to attend. It's just you that's speaking up for the landowners.
That's correct.
That's fine. That'll do me for that. Okay, now I did have a couple of points in and around the landowners that's convenient to bring up here. Mr. and Mrs. Gregory, are you the owners of Forest Park rather than tenants or anything?
Yes,
you own the land.
Yes.
And do you actually reside on the land, or do you reside elsewhere?
Yeah, it's our home and business.
Home and business, that's what I wanted to know. Now, I don't know anything about the park yet. I've taken a wee look at your website, nice website. There's no other permanent residents on the land, is there? Is there anybody in a permanent caravan or anything like that?
No, it's purely a holiday park.
Just yourself and the holiday park?
Yeah.
I just wanted to check that there was nobody who could be designated an occupier who would perhaps need to be involved in this. Now, that all cleared up. I want to move on to item 3, which is just to explain to you why I've called this meeting and what I want to get out of it. The purpose is to discuss and prepare everybody for the steps I want to take towards the preparation of my report. It's a chance for everybody to get a good grasp on the process and to understand what my expectations are about the presentation of the evidence in the cases. We're not going to get into the merits of either party's position this morning. This is all about setting up an effective and efficient investigation process for me. It's all about the best procedure to adopt and what everybody has to do to muster their evidence and help me get a clear picture of all the issues. Now, moving on to item 4. Well, I should have said, have you got any queries? Any questions about what we're trying to achieve this morning? Everybody get a bit of a handle on what's happening. Jolly good. No, moving on to item 4. So the shorthand title for this type of application is a necessary tree cutting order, and it's quite unusual. If you look at the DPA website, there's only a handful that have ever been brought forward. So to some extent, we're forging a little bit of new ground on exactly how these should be handled and how they work in practice. This is all about Schedule 4 of the Electricity Act 1989, which I think, Mrs. Gregory, unusually you'll be familiar with. Not many people have the disadvantage of getting to know Schedule 4 of the Electricity Act 1989. What I think is clear to everybody is that SHEE, Scottish Hydro Distribution, is a holder of a distribution licence in the area of the park under the Electricity Act 1989. Now, there's a great deal of other functions and powers and duties in the 1989 Act, which won't necessarily come into play here, but are nonetheless in the background. And there's regulations and there's other powers under the Act for licence holders. But Schedule 4 of the Act, I think it's fair to say, is broadly about enabling the logistics of electricity delivery on the ground and the powers of a licence holder to do essential things on other people's land on a compulsory basis. Would you disagree with that summary, Mr. Ryan?
No, not at all.
Mm-hmm. Now, Mr. and Mrs. Gregory have already been subjected to an application under another paragraph of Schedule 4. That's the one about way leaves. So I have an awareness of the way leave, Mrs. Gregory, and I think you're referring to it yourself also in your statement of case. But paragraph 9 of the schedule makes provision in relation to the felling and lopping of trees. And I think it's quite important to be really focused on what paragraph 9 says. It applies where any tree is or will be in such close proximity to an electric line or electrical plant which is installed on land by a licence holder, so as to obstruct or interfere with the installation . Sorry, I froze.
Sorry, you froze again. Yeah, briefly.
What I was saying was, this is subparagraph 1, subparagraph B, to constitute an unacceptable source of danger, whether to children or other persons. And in this paragraph, the land means the land on which the tree is growing. Next, the licence holder may give notice to the occupier of the land, requiring him, that's the landowner, to fell or lop the tree or cut back its roots so as to prevent it from having the two effects mentioned above, subject to the payment to the landowner by the licence holder of the expenses reasonably incurred by him in complying with the notice. Okay. I asked about whether there was an occupier, but there isn't, so I think we can skip over a little bit of the paragraph. Sorry, another freeze.
We've got you back.
If within 21 days from the giving of a notice, the requirements of the notice are not complied with, and neither the owner or the occupier of the land gives counter notice, the licence holder then may cause the tree to be felled or lopped or its cuts to be brought back. So that's the circumstances in which the licence holder could go onto the land. If within 21 days the owner or occupier of the land gives a counter notice to the licence holder, the matter is to be referred to the Scottish ministers. And as we know, Mrs. Gregory, you've served a counter notice. So, subparagraph 6 lays out the powers of Scottish ministers, and it's really important. I'm standing in the lieu of Scottish ministers, So I really need you. This is getting a little bit disruptive. To what extent is it disrupting your hearing what I'm saying, folks? Have you missed anything of what I've said?
I don't think we've missed anything, because you've picked up on the bits
Mm-hmm.
where you're frozen. It's just, yeah. But don't think we've.
I'll call in the troops if it keeps happening. I don't think it's me, but it might be my service. Just shows you. Now, what was I saying? Ministers, I'm looking at subparagraph 6. Ministers may order, so they may empower the licence holder after giving notice to cause a tree to be felled or lopped, or its roots to be cut back so as to prevent it from having the effects mentioned. And this is important, it may determine in any question as to what expenses, if any, are to be paid. There is a the expenses of having the work done, who pays for the actual lopping, and any compensation that may be payable. And just to be clear, compensation is not something that I or the ministers will be looking into, Mrs. Gregory. That's something that is dealt with elsewhere. But if it should be the case that the trees do have to be lopped, you may be in a position to claim compensation through another process. Is that something you've been aware of?
Yes.
Do you know about that? Yeah. Okay, good stuff. Now, subparagraph 7 says, where the licence holder exercises any powers, he shall, A, cause the trees to be felled or lopped or their roots to be cut back in accordance with good arboricultural practice, and so do as little damage as possible to trees, fences, hedges and growing crops. Next, cause felled trees and C, make good any damage done to the land. Okay, so we know as a matter of law that if it should be that ministers grant the order, the work will have to be carried out in accordance with good arboricultural practice. I think it's appropriate to bear that in mind. And the definition of tree includes any shrub, and references to felling or lopping or felled trees or lop boughs should be construed accordingly. So it could be a tree, but it could also be a shrub. Right, that's what subparagraph 9 says, or paragraph 9 says. Does anybody have any questions about that they'd like to raise just now?
No.
Mr. Ryan, Mrs. Gregory, have you got any questions about that process you'd like to raise just now?
No, a lot of that was covered with the previous way leave as well, because it came up with that, and it was for SSEN to actually do all the work.
Mrs. Gregory, I'm terribly sorry, but just as I asked you to speak, the system froze again. Can I ask you to restart? I didn't hear what you began to say. I do apologise.
Yeah, a lot of it was covered under the previous way leave agreement, and I'm not sure what page it was, but it did say that because SSEN didn't want us to go anywhere near the green area of the way leave, that they were responsible for the cost and for all the cutting.
Right. I'll bear that in mind, Mrs. Gregory. But remember, we're trying to get to the point where you have a chance to see all of these things, and so I'll bear that in mind. But you feel you've got an understanding of exactly what's in paragraph 9. Is that?
Yeah, I've got a copy of that, and I have to do it, yes.
Yeah. Point 6. So starting here. Oh no, there was something about this. Mrs. Gregory, there was something you said in your statement of case. I'm looking at your outline statement of case. It said it's been brought to the Secretary of State to clarify the extent to which this Act applies. I just wanted to be clear, is it going to be part of your case that the Act doesn't apply to this land? Are you quite happy that the Act does apply?
Yeah, certainly, and we've been here 11 years, so obviously SSEN have been on the land and they have been doing the obviously the cutting, but now they actually want to extend the time and obviously the extent of what's removed, whereas it wasn't before, and that's the issue. We're not against the 3 metre that people can climb on, or the 0.8 that's going to be touching the lines, and it is in excess of that already.
It's not the case that you're going to suggest or argue that the Electricity Act and Schedule 4 doesn't apply to the land, are you? You're not going to argue that?
I mean, health and safety, being a holiday park, is paramount.
Yeah, we're going to circle right back round to that, because you're absolutely right. This is going to be central to what I'm going to investigate. Now, I'm moving on now to agenda item 6. Here's hoping we don't have too many freezings. I'm going to summarise the main points of your case for you, because from the summary of your cases derive my identification of the issues that I have to investigate. Now, as usual, Scottish Hydro have alluded to the statutory background and the licence background against which your powers are exercised. So I'll not go over those in any detail. You do touch on a number of points that are hard not to describe as anything other than technical, and that's the interaction between the ESQC regulations and your general regulations. So you refer to all of these and you say that these apply. In order to improve the reliability, you quote from the Electricity Safety, Quality and Continuity Amendment Regulations 2006, avoidance of supply interruptions caused by trees. And you say, in order to improve the reliability and continuity of supply, so far as is reasonably practicable, distributors will expect to have appropriate policies, procedures, resources and programmes in place to ensure sufficient clearances are maintained so as to avoid contact, electrical or physical, between them. So you don't there go on to specify what policies, procedures, resources and programmes you do have in place. Can I expect to be told about your policies, procedures, resources and programmes that will be in place for this situation?
Yes. Those are part of the documents that were that set out in the list of documents. But I think essentially there's 3 or 2 documents that are referred to there that are probably the key ones outside of the legislation, which is the Energy Networks Association overhead line clearances technical specification, which is document 50 in the list, and then the ADAS review of predicted tree growth rates, which is document 48. So between those, they specify the minimum distances and then the predicted growth rates of different types of trees, which then speaks to the amount of cutting back beyond the minimum clearances, which then comes back to the point that Mrs. Gregory has raised about the period and frequency of the cutting required.
Yeah. So you are going to provide me with a full picture of how your clients usually go about keeping lines clear of trees?
Yes.
I'm quite keen to keep this as practical as possible. I think I mean, you know, at the end of the day, the regulations say certain things, but somebody's got to apply a saw to a branch in a competent manner. And I'm quite keen to be clear about exactly what you envisage is required. So although I'm expecting you indeed to show me how you go about the liaison with customers and what your standards are, let's not forget that it has to be about the practicality of the actual moment of works.
Yep.
Now, you then go on to say at your paragraph 10 in your statement of case, the trees at the application land are in such close proximity to the equipment owned by yourselves that the trees are obstructing or interfering with your ability to comply with industry guidance. I think I'd like you to be a lot more specific about how exactly they're interfering with your ability to comply with. How are they affecting? Is your ability to comply with industry guidance? Let's go from the general to the specific. If they remain unmanaged, so you're saying that the trees are unmanaged, the trees will continue to constitute an unacceptable source of danger and risk to the network. So it says at paragraph 11, the trees are in such close proximity so as to trigger both of the standards. And then on 12, you say, on this basis, it is essential that SHEPT are able to undertake vegetation management on the application land. So it would appear that in your case, you appear to have closed down the option of the landowners taking action themselves. Is that your position?
Perhaps, Mr. Innes, you have some comment on this as well, but I think it's that we wouldn't necessarily rule out the possibility, but what it essentially comes down to is health and safety risks, and our position would be that it would be better to have expert arboriculturalists on site to carry out the work.
You froze again, Mr. Ryan. Oh. This is one of the reasons why virtual meetings are not quite always what they're cracked up to be. Mr. Ryan, you froze on me just as you were touching on health and safety matters. Could I ask you to pick up at that point?
Sorry, yeah. So essentially, I think it's primarily a health and safety matter, and the preference would always be that trained arboriculturalists who are used to working in proximity to these type of lines would undertake the work, and also then that we could be confident the work is carried out to the required standards. Mr. Innes, I don't know if you have anything to add.
Yeah, no, I think you did perfectly well there. I think we're trained on the utility side of it for arboricultural with the correct tools for working near. We've got to remember this a 33,000 kV line. Is for us up in SHEPT is the biggest, highest power line that we work with within distribution.
Sorry to interrupt, Mr. Innes, but I've got quite serious distortion on your sound. I'm not really clearly hearing what you're saying. I'm sorry about that. I'm not sure why. But the question, I think if it's okay with you, Mr. Ryan, having flagged up the issue, which is really all I'm concerned to do in this meeting, I'm bearing in mind that I've gone over the legislation to highlight for you that, the ball does start in the landowner's court, and it's not something. I'm wanting to be clear about exactly why you think that particular provision should in some sense be overridden. So that's important. Let me just check. I'm still on the applicant's case here. Right, okay. And then you have quite a lengthy list of documents, I have to say. I'm aware, of course, of my colleague, Mr. Caquette's previous procedures, and in fact, I'm aware of his report because I expected it to come up, but I have not discussed with Mr. Caquette anything that he has heard by way of evidence in any beyond that point. That's important. I'm bringing that's a completely fresh perspective, Mrs. Gregory, there are certain things that follow from what Mr. Caquette found to be the case in his recommendation to ministers. You may well want to say things to me about that, but I will come to this matter with a clear blank page, just so as you know. And you've given me the way leave itself in its terms. And then I think you've got quite a substantial email trail of your correspondence with Mr. and Mrs. Gregory. Is that correct?
Yes. I suppose that was all included in there just to sort of provide context to
Yes.
where we are now.
Yes. And then I see that there was a dangerous situation notice served in January 23. Was that resolved, or is that part of the matters that remain unresolved?
I believe that's still ongoing.
Since 1923, since 2023. What's the relevance with the agreement between the Hydro Board and Glen Moriston Estates?
Probably not a great deal. I think we can sort of review this list, and there may be a couple of things to take out of it.
Well,
that might be one of them.
That warms my heart, Mr. Ryan. If there's anything you can do, I mean, I think you can take for granted, because Mr. and Mrs. Gregory appear not to be challenging it, quite a lot of your clients' powers.
Okay.
Obviously, we may need to look at them. Tricky judgment, but if there's anything that you feel that isn't particularly helpful to what I have before me, please think about taking it out of my reading list.
Yes, I mean, I don't know whether you would find it helpful. What we've done on previous appeals is to separate the documents out into, I suppose, the sort of the factual background, and then have a separate set which is the sort of legislation and guidance. So I mean, that would still include the sort of extracts of the relevant legislation and powers, but we've sort of put that as a separate set of documents, if you see what I mean. I don't know whether that would assist.
Headings are always useful, so yes, grouping them would be very helpful. I did actually have a query, Mr. Ryan, when I came across an English document. This something I've come later in the agenda, but this is kind of worried me slightly. I came across a Department of Energy and Climate Change statement of guidance for applicants and landowners and/or occupiers in January 2014. I don't know whether it's still in course. It's still in force. It was an internet search just because I would conform myself as to what guidance and policy might be available. I do quite a lot of way leaves. I can't remember coming across this English document before. The point I want to make about it is the Scottish version of guidance extends only to way leaves. This one includes recommendations about the felling and lopping of tree orders in England and Wales. Now, I don't know why there's guidance for England on unnecessary tree cutting orders and apparently not in Scotland. But first of all, is that the case? Is there something I'm missing? I must say nothing came to mind, and we are, I hope, the people best placed to know about these things. And I couldn't see a Scottish guidance note about necessary tree cutting orders. Are you able to tell me what the position is about Scottish orders?
Yeah, we're not aware of any equivalent guidance.
Right. Well, I don't know why the Scottish version doesn't have tree orders, but this seems to me to have a number of points of potentially helpful guidance. My inclination would be, with all the usual caveats, to have regard to this. So I think I'd like this to be included in your productions, your documents.
Yeah, no problem. Sorry, could you repeat what the guidance is?
It's called Guidance for Applicants and Landowners and/or Occupiers. Then the subtitle is Application to the Secretary of State for Energy and Climate Change from the 1st of October 2013. for the grant of a necessary compulsory electricity way leave, or felling and lopping of trees order in England and Wales. And the version I found is dated January 2014.
Very good.
Okay,
Yep.
so Mrs. Gregory, you're going to get all this stuff, you know, but you could find this yourself if you had a search. And just for your own information, it's often the case that there's some difficulties about transposing English practice into Scottish practice, and devolution has just complicated the issue. But in the main, the practicalities tend to be dealt with along similar lines either side of the border. So it may be of some interest to you, and it certainly I would like to have it referred to, so I know we know what we should be doing. So now, turning now, I think, to Mr. and Mrs. Gregory. You did say in your first sentence of your outline statement of case that you've brought this to the Scottish ministers to clarify the extent to which this Act applies, when you've confirmed to me that you didn't mean a general application. I think what you really mean is the extent to which the Act applies in this case. I'm perhaps a wee bit getting the right end of the stick there, Mrs. Gregory.
Yeah, because the sort of minimum tree clearances have always been adhered to on the park, and we've never had any problems with that. But they're now asking for in excess of that. So I'm concerned how much in excess they can actually go.
Well, one of the things I am going to want to know is exactly what they're proposing.
Yeah.
Now, you're saying in this that you've only been provided with a rough plan dated June 24, rather than a scaled arboricultural survey plan, which you requested in November 24.
Yeah.
And you say that there's been a breakdown of trust because you're critical of the manner in which the applicants have carried out works on your land before. Is that fair to say?
Yeah. It's it's not been pretty, the work that they've done.
You say poor arboricultural practices carried out by them, and you also mention that they decided to postpone the removal of uninsulated bare wire overhead 33 kilovolt lines. So are those still in place?
Yeah.
I think I'm right in saying that there's been an extended area of time of discussion about undergrounding the lines
since 2015.
Yeah, and that's been a dialogue. Is that your position?
Yeah. I mean, with emails and phone calls, on-site meetings. And
you actually asked them to take it away, and that's what led to the necessary way leave process, which of course resulted in a grant of way leave.
Yeah, because we're responsible for the safety of the guests, and having that the SSEN measured them, then they are below the height as well. So it's below the licensing.
That's what you go on to say. You say, according to their own measurements, the current infrastructure does not meet the minimum standards required for power lines over a holiday park. When you say power lines over a holiday park, were you able to find a specific recommendation in the documentation about holiday parks? Is there something specific to holiday parks?
Yeah,
so
I mean, I found.
Don't worry looking for it, but you can. You're able to say precisely that holiday parks have to have a certain clearance.
Yeah, it's on our licence as well. It has to be 6 metres.
6 metres clearance from the ground.
Yeah, and with a holiday park with roadways, it's the whole of the park, because any place that vehicular traffic can go has to be classed as a roadway.
So that's I'll get you to. I'll need you to be absolutely clear about exactly what point you're making when you expand your case, Mrs. Gregg. You really need to give me chapter and verse on that. Now, you're saying that the lines were measured in May 21 at 5.73 and 5.76, which you point out, even without an ice load, is below the height prescribed in the regulations. And you're saying that under those regulations, the lines can't be used if they don't comply with the regulations.
Yes, and
you want to make a point about that.
Yeah.
And then in the IEE regulations, caravan park installations, if overhead supplies are used, they must be constructed with insulated rather than bare cables and be of a minimum height of 6 metres where vehicle movements are possible. Since in most cases the whole of the area of the caravan site is subject to vehicle movements, most overhead systems will need to be at a minimum height of 6 metres. The Electricity Act 1989 grant of the necessary wayleaves states the installation of the electric line shall be executed by the company in accordance with all statutory regulations applicable and for time being in force. Now, the next part, I'm not sure exactly what you're saying here. Line conductors to that part of a tree, under, adjacent to the line, and unable to support ladder climber, and then capable of supporting ladder climber. What did that bit mean?
That was that was the minimum safety clearances.
Oh, right.
Yeah.
I see it. I get a bit. That's a little clearer to me now. Now, you then go on to say, previously the maintenance cycle carried out by the applicants and yourselves, so you've been doing your own work too, has been to these distances. But now the applicants only want to visit every 4 years, so they want to cut more than before from the trees. Is that what you understand to be the position?
Yeah, and that's the problem.
Mm. And you're making the point that they're there for the amenity of the park, and you're also making the point that your park is about outdoor recreation. It's a kind of I would, without in any sense intending to be pejorative, I would regard it as a sited campsite. It's a kind of high grade campsite, really, isn't it?
It's a caravan park. We've got cabins, and we've also got touring as well.
Yeah, I'll see all that when I come up to see it. Remember, I haven't seen it. And you're saying you have to maintain frequent good arboriculture practice that results in some trees, shrubs, etc., needing to be maintained 3 times a year by us, while others, having reached maturity, needing very little pruning. And then you're making the point that arboriculture is not an amateur exercise. It requires a certain amount of expertise. Do you have your own arboriculturalist?
My husband is trained horticulturist.
He's got some qualifications.
Yeah, he was the manager of the grounds maintenance team as well for one of the councils. Right.
So he's got both experience and some qualifications. Is that fair to say?
Yeah.
Right.
Many years.
Again, I want all the details on that. And then you say the increase of open areas due to this new increased distance, that's to say pruning back the trees harder, shall we say, would also increase risk due to the open area available for vehicle movement, recreational areas, and then remove the screening. Now, I wasn't quite sure what you meant by that. Are you saying that if you radically cut back the trees, it'll be harder to manage movement within the park? Is that what I'm understanding?
Yeah, because where they remove them, obviously more vehicular traffic will be able to go there, and also the guests will be able to do more activities.
Yeah. So you're saying it's going to change the way in which the park is used by people, by clients, by people staying in it,
and also wild campers as well, because they open areas, they will wild camp even though they're not supposed to.
Right. But then you said remove the screening required for the holiday park. Did you mean internal screening or the screening of the park itself?
Yeah, the screening to the neighbours as well.
Right. So on that point, do you have any planning conditions or perhaps license conditions that require you to keep the trees in any particular way?
But we, the Highland Council do say that we have to have screening around the whole of the park, and also it has to be kept tidy.
That, Mrs. Gregory, when you're building your case, I want to know all about that. Okay. Now, then you go on to say the Electricity Act states where the license holder can, yeah, that's okay. But one of the things I think you're saying, I'm not sure where I saw it. I think you're actually saying that they're not complying with the current wayleave conditions. Is that the case?
It's because the bare lines are below what they're supposed to be.
Mm-hmm. Right. Okay. So I think that's me summarised what you have outlined in your outline statement of case. Is there anything that I've not touched on that you'd like to highlight just now? Remember, what I'm trying to do is work out what I've got to look at. So have I got hold of, do I properly understand your case from what I've said?
Yes. I mean, also the woodlands that we've got is it is an ancient woodland, so it would need a forestry commission permission.
Yeah.
Felling work.
Well, no, that's very interesting. There is some interaction between the forestry regulations, and it's quite technical. But I certainly want to know about any potential environmental effects that you envisage for the implications of the work. So I need you to tell me all about that. Everything. Bats and owls and
we've got it all here. We've got pine martens, red squirrels, we've got various bats, we've got lichen, we've got everything.
Mr. Ryan,
David Bellamy Gold Award-winning park.
Hang on a second, Mrs. Gregory. Mr. Ryan, I trust you wouldn't suggest that any of this would be irrelevant to the process that I certainly consider that I would require to advise ministers on the potential environmental effects of what your clients are ultimately proposing. You're not suggesting these would be an irrelevant area of inquiry?
No, there wouldn't be. And I mean, it would be necessary to sort of comply with the sort of relevant wildlife regulations and restrictions. I mean, the obvious one is the times of year that cutting can take place. But yeah, I wouldn't disagree with that.
Good. Thank you very much, Mr. Ryan. That's important. Mrs. Gregory, you've got to tell me all about that. And it is important, not just telling me, but also providing me with some evidence, actual material about it. Some things I will be able to take from yourselves, but for some things I'll need backup. Your own. If you're not an expert person in a particular field, you need to either give me the paperwork or whatever. Do you understand what I'm saying?
Yeah. So okay.
Yeah. Jolly good. Now, that's fine. So that's me summarise your cases. Going back to my agenda, I'm still on item 6, and these are the second part of my agenda, item 6, are what I think the issues are going to be, and I'll just go over these. Exactly what works are proposed into which trees and shrubs? Why is the work necessary in each case? Who is best to carry out the works is probably a good way to put that. And when, and what are the short-term and long-term implications of the proposed works, and what orders should be made as regards to the expenses of the works. These seem to me to be the issues that matter. Now, first of all, applicants, do you disagree with that list of issues? Is there anything that shouldn't be there or anything that should be there?
Just the one thing that I'd like to clarify, it's really in relation to points A and B. Would you be envisaging that there would be a full and detailed arboricultural survey provided as part of the our statement of case. Now, there's the plan will be provided. I don't know, Mrs. Gregory has seen, which shows the different trees and bushes and shrubs that have been identified for cutting, and where the standards would be, where there would be where they would be implemented. But would it be the case that you would be expecting to see a full and detailed survey? And the reason, I suppose, just following up on that I ask is, in previous cases where we've obtained an order, those have been, whilst obviously there's been site visit and discussion about the necessary and applicable standards and timings and all those sort of things, the order would be subject to a qualified arboricultural survey prior to the work being undertaken. So it'd be helpful to understand the level of detail that
first of all
require.
That's a matter for you, Mr. Ryan. That's a matter for you. But what I would say is my reading of the regulation, and actually my reading of the guidance that I just referred to, the English guidance, is that it is highly specific. So, what I have to bring forward out of this process, either apart from refusing you your order, or recommending refusal of your order, I should say, is telling ministers exactly what the order should contain. Now, I have not seen the site. I'm basing it only on my general knowledge of the area. But, we're talking about a fairly sensitive landscape environment. That's without knowing anything about any classifications that might be in place. The decision is yours, but I think my reading of it is that the regulations envisage a very specific order being given, and if that's the case, I would imagine that it is. I don't see these as giving anybody carte blanche to do anything, but I may be wrong about that. That'll be for you to argue. I don't know if that answers your question.
No, that's very helpful. Yeah,
I'm not at this stage prepared to make a procedural order that you do a particular thing. I think it's something I must leave with yourself to take the risk of. But I mean, without having seen it, I can imagine that it's a fairly sensitive environment. Mrs. Gregory has already alluded to the fact that her license requires her to maintain screening to a certain degree. That's not at all surprising. So there's a balancing act very likely to be made here, but I think it's highly likely that you will need to be able to tell me exactly what you propose. But it's up to yourself to make a decision on exactly how far you go on that. I'm not prepared to make an order for it. It's up to you. Sorry, was that one of A and B? Was there anything else about Mr. you wanted to raise about my issues?
No, that was it. That was helpful. Thank you.
Okay. Right now, Mrs. Gregory, these are my issues. Is there anything else you think, if there's something I've missed out or something that I shouldn't be looking into?
No, but it's to do with the line heights. Obviously, that does have an impact on what needs cutting, because obviously that's makes them nearer to, and removal of them obviously causes problems. But that now the way leave ruling has been done, we're not allowed to cut anything. So it means that we're in limbo at the moment. Do we sort of break that rule to keep the park tidy, because we've got to keep with licensing?
I think that comes to me. I think I've got that in with my issues, Mrs. Gregory. I think I'm going to be having a good look at that. I think. Now, there is something I should mention to you. I mean, I do quite often come across situations, in fact, these situations almost invariably arise, where there have been a breakdown in relationships between the landowners and the power company. It happens in lots of situations. And one of the things to bear in mind is I don't have power, or for that matter, interest to assess the actings of the power companies. That has to be looked at through in other places. I've just got the bit of black letter law in front of me that it's been asked ministers to exercise, and I have to decide whether or not it's justified against some fairly narrow and brutal criteria. But if you feel that the power company have not treated you properly, or if you feel that the power company is not complying with its regulations, I'm not necessarily likely to be able to look at all of that or make any findings on it. That's usually what you could do, is you could complain to the necessarily regulator or whatever, but it may be that some of the area of that, maybe that some of it will be I will find relevant, and ministers may find relevant, but it's quite likely to be bad behaviour on behalf of the power companies is not something I can look into or take into account. See where I'm coming from on that?
Yeah, we understand that, and this is what's made us less trusting and needing evidence. And because they haven't given us that arboricultural plan, we don't know what they're actually going to do. And previously, with their rough plans, when we've agreed it, we've walked the site, we've had phone calls, it's been on the plan. They've come here on the day, and they've caused so much damage and left so much debris for us to clear up. And so we haven't got time to clear up after them, and we have to do that. With stumps that have been left that are obviously a trip hazard for guests, or that they could, potentially drive into. That there is still an old stay line that's sticking out in the woodland, that was there from many years back. We haven't got an ability to get rid of that.
Well, you're going to be able to show me these things.
Yeah, but that's all we ask for. That's, had they have done that plan and said how much was
going to be able to show me these things. But what I wanted to say was, I won't always be able to take them into account. I'm just giving you a bit of a warning shot about that, because I do understand that often the motivation on the part of the landowners is about a much larger situation and a longer history. But it's not always going to be possible for me to fix everything, is really what I'm saying.
And
there may be other avenues. Yeah. Okay, so that's good. I think looking at my agenda again, I think that we can move on to agenda item 8. I think I've got broad agreement to my issues, but of course they'll be kept under review. And when I see your full statements of case and moving forward from that, I will obviously, if the issues need fine tuning, I'll expand them or even maybe perhaps reduce them. But I think I've got broad agreement that I'm looking in the right areas. Is that fair to say, Mr. Ryan?
Yes, I don't, just checking nobody else on the call has anything to add from our side.
Good. Have you made that check?
Is that
yeah?
That's what I'm asking now.
Gray.
So yes.
Do you have broad agreement? Do you broadly agree that I'm looking in the right places so far, anyway? Yeah, you don't have anything else you want me to add? Okay, right. Now, I want to move on to agenda item 8. That's what I've got under the heading, the hearing. And I just think this is a good round table case. I think this is one where a hearing is advisable. Has any of you been? I think the last thing with Mr. Kickett was all written submissions, wasn't it? Is that right?
I believe it was. Yes.
You didn't have a hearing. Well, the legislation does provide that the point one is that you get the opportunity to be heard, Mrs. Gregory. But it is possible to do that via written submissions, and indeed most things are done by written submissions these days because everybody finds them convenient. But I've been doing this for a long time, and I know perfectly well that sometimes that's a little bit difficult. There's things you might want to say that you don't say in the written submissions, but if you're around the table, you do often get an opportunity to really get to the bottom of things in a dialogue. And I think this is a classic case for that. There are about, I think I'll just go over the 4 procedural options just to sort of let you know what ways we could do it. I will definitely be going to the site and carrying out a detailed site inspection. That's definitely going to happen. But the other procedural formats are, first of all, an in-person public inquiry. That's the most formal exercise. The witnesses present written statements, and these people are cross-examined, and it usually involves lawyers. It doesn't have to, but it usually does. I just don't think this is a case for that. The second option is an in-person hearing, which I'm currently thinking is the best format. Now, a hearing, if you haven't done one, is a structured meeting where the evidence gathering is proactively led by the reporter. I chair the meeting. The advantages of a hearing format is it's very flexible. It's a good way to get to the heart of the matter. And I've got a strong inclination this is the best fit for this problem. The third option is also a hearing, but held virtually. And that's how the substantial majority of cases are heard these days. Not ideal, as we've just demonstrated. Sometimes things freeze in the minute and they can be disrupted. They're also much more time consuming and actually they can be quite exhausting. Virtual hearings can be surprisingly tiring for everybody. You have to have quite a few breaks usually. And I don't think I think it's just going to pull out the process. I don't think it will have any particular advantages. And in this case, I'm thinking that written submissions aren't really the written submissions that you've done. It's lots and lots of writing, lots and lots of homework for everybody. And I think we can do better than doing that. I think the best fit is an in-person hearing. My concept is that I'm up in Fort Augustus. We start fairly early in the day. We go carefully around the site, which will probably take us at least a couple of hours and perhaps more. We then have a break, and then we go to a public hall, which I'm hoping would be the Fort Augustus Public Hall, sit round the table and have the hearing. And I think if we do that, we'll get the whole thing done in a day. So that's my humble opinion. What does everybody else think? Mr. Ryan?
Yes, I mean, we had suggested written reps as an alternative, but a lot of that was, I suppose, guided by concerns I think that had been identified previously about Mr. and Mrs. Gregory and health issues, and whether they wanted to be in close proximity to other people. So that's really a matter for Mr. and Mrs. Gregory to address. But we I think certainly sympathetic to your views on the sort of informal in-person hearing approach, and entirely in your hands on that.
Yes. So remember, this is just the evidence gathering process. Mrs. Gregory, is there anything about this doesn't suit you?
With obviously the on-site meeting's not a problem, but it's only likely that one of us will be able to go to the meeting because one of us needs to be running the clock.
Yes, that did cross my mind. I mean, it's still September. It's summertime.
Yeah.
Does it need to be both of you?
No, one of us can attend. But I've got 2 children. They're both teenagers as well. But yeah,
they might be a good help.
Be here. Yeah.
Well, I'll bear that in mind. A lot of this will be done beforehand. I mean, the idea is I will be asking questions about the things I'm interested in. So it's a reactive thing. You don't have to come up with any questions yourself necessarily, although obviously you have the opportunity to ask questions too. But you could do it, is what you're saying. You could do an in-person hearing.
I still wear a mask indoors, but that's because I've had ME for many years.
Oh,
So
yeah.
so yeah, that I can't be vaccinated, which is why I do wear a mask. Because, you know, just as an extra precaution.
Well, if you have a health condition that means it's difficult for you to keep concentrating, I am the first person who's happy to have breaks and cups of tea. The other thing about this is it doesn't need to be in public. I'm thinking about asking for a committee room, and either party can ask for it to be held not in public, and I think that's what we should do here. So that would lessen the stress a wee bit and also lessen the number of people who might be involved. I'm hoping it'll be a big enough room, but for given your situation, your vulnerability, I'll make sure that it's big enough so there's enough space and enough air. Is that all helpful?
Yeah, I mean that there is also a community centre with meeting rooms over at Invermoriston.
Invermoriston itself is there, right? Yeah. That's very helpful to know.
Which would mean that we don't have to drive.
And it's a community centre.
Yeah.
Right. Well, I was going to ask you about venues, and you know, Fort Augustus just occurred to me because it seemed to be the only one that was online. But a community centre in Invermoriston is obviously more helpful, and they've got suitable committee rooms. You think?
Yeah, yeah. At SSEN, and they have hired the hall, and when there's been meetings and things, they have used them. Great,
good, excellent. Now, there's quite a few things going to rely on availability, of course, but we'll come back round to that. Okay, so I've bullied you all into having an in-person hearing and a site visit, so that's fine. Always good to get my own way. Now, next thing is preparation for the case. What I wanted to, I make the point particularly to Mrs. Gregory, you have to tell me about things. I mean, I will do a bit of research just to make sure that I'm absolutely in the right area, like coming up with that English document. But you can't. I'm an empty vessel as far as both the parties are concerned. If you don't tell me, I won't know and I won't be able to report on it. So it is important that you tell me all about things. If you, the glory of a hearing is that it's like the tip of the iceberg. It's the time to look at the areas that are in dispute. But other thing that is submitted and written is also taken into account, even if it isn't necessarily touched on in the actual hearing itself. I'm very against ambushes. I don't want anything pulled out of the hat at the last minute. You know, I'm quite likely to disallow evidence if it hasn't been foreshadowed properly in the statements of case and in the documents. So, I'm going to need a full statement of case from you, a comprehensive statement of case. You've given me an outline. I want the full statement of case and the documents which back it up, what you see in the statement of case. Now, I think actually I've covered what I intended to cover in my agenda item 11. So my agenda item 12 was my next sweep up thing. Does anybody have any questions to raise about the statements of case and documents that I've touched on, particularly Mrs. Gregory? Does anybody have any questions to ask of me? Okay. Now, we're going to have a site inspection, and you've already experienced one. I gather Mr. Caquette's had a few surprises in it. Things came up for discussion that hadn't previously been warned about. So quite like that not to happen. So as we move towards the site visit, I'm probably going to literally ask for a plan and a itinerary around the site. And that might be something you might want to get together on as we move towards it. I'm not necessarily going to be deterred either by weather or by midges. I think we'll short of a gale, which heaven forfend in September, but who knows these days. We'll have the site visit, notwithstanding any weather or anything. Okay, so I think that means that we can now move on to talk about the programme, the actual dates, and the logical way to do that is to choose the date and then work back from it. Let me just find my programme. Yep, I circulated very much a draft programme which was tailored to my own situation as much as to anything else, just to let you understand I am a carer. And when we hold this inquiry, I'll have to make careful arrangements to ensure that there's cover. So my own availability is a little more circumscribed than normal. But what do we think about holding the hearing and the site visit on Wednesday, the 3rd of September? Mr. Ryan, how about the applicants? Could you do that?
Yes, that could be.
You could do that. You could
do
that. And how about yourself, Mrs. Gregory? Could you do that?
Yes, that's fine.
Well, that is splendid. That is absolutely excellent. I will try for that date. We'll try and book the hall for that date. And if there should be any snags about that, obviously we'll get back in touch with you as soon as possible. But if we've got agreement about that date, then it means that the rest of my programme would apply. Does anybody have any difficulties with that? The key date now is Wednesday the 13th of August, when you put in your main statements of case and your documents. Now, that's 3 weeks prior to the hearing and the site visit, so it gives me plenty of time to look at it and ensure that I've got everything, understanding everything that I need to. Could you comply with that, folks?
Our preference would be to have a little longer than that, if at all possible, just bearing in mind the today's date.
Yeah, but I gave you. You can't say I didn't give you warning.
No, I know, I appreciate that.
I assume you'll have working away on it. The difficulty is pushing it that back a week. It means that I have less time with it, and since yours is going to be the most substantial portfolio, I'm a bit hesitant to give you another week. Could you please try your best to comply with the 13th of August?
Yeah, or possibly even maybe pushing Mallock here just out to the Friday the 15th.
Well, no, I don't have a problem with that. And you will ensure that it's also contemporaneously copied to Mr. and Mrs. Gregory, won't you, Mr. Ryan?
Oh, yes and no, of course. We'd be sending it out at the same time.
Okay. Mrs. Gregory, Mr. Ryan suggested giving himself another half week or so, the 15th of August, the Friday, the 15th of August. Can you make that date okay?
Yes. That extra couple of days will help.
Good. I'm delighted to be able to do that. And as I have said in the programme, after I've analysed your material, I'll prepare another agenda for the actual hearing itself, and that'll be issued on the Wednesday the 27th, or as near as I can make it. Okay. Well, that's extremely helpful of you to be able to accept my programme. That's really good. Okay. And Mrs. Gregory, thanks for that reference to the Invermorriston Community Centre. We'll take action about that. Now, the next thing that will happen is that I will prepare a note of our discussions this morning, and that will contain my formal procedural directions. I'll get that out in about a week from now, sooner if I can make it. And that should leave everything clear for you. That's the sort of definitive outcome of what has happened this morning. But that's what to build on, is what I say. Now, that's everything I had to say. Does anybody have anything else they want to raise this morning? Mr. Ryan, anything else?
I don't believe so, no, thank you.
Mrs. Gregory, do you have anything you want to raise?
No, thank you very much.
Okay. Well, if that's the case, being very smug about my programme being accepted by you, that's very helpful indeed. I'll close the meeting. Thank you, everybody, and I'll see you later on in August. September, I should say.
September. Yep.
Okay, right. Goodbye, everybody.
Thank you.
Thank you.
Thank you. Goodbye.